Well, thank you all for being with us. We're so appreciative to have you each week. Good evening. I'm Janice Kaminer-Resnick, and I'm delighted to welcome you on behalf of myself, former Congressman Mel Levine, and former Los Angeles County Supervisor Zev Yaroslavsky. That's our America at a Crossroads leadership team. A special welcome tonight to our guest, Mark Stern from Slate. You'll hear all about him from Larry Mantle in a moment. We're all very interested in hearing his take on cases pending before the appellate and Supreme Court and his observations about the state of our justice system. Welcome as well to our wonderful moderator, the great Larry Mantle. And in the spirit of Thanksgiving, I want to thank, on behalf of Mel and Zev and myself, I want to thank our amazing audience for responding to our solicitation for donations. We recognize the special qualities of our audience and thank you for expressing your appreciation of our work by responding so generously to our annual appeal. You have assured and ensured our programming for the important midterm election year 2026. And if you had not had a chance to donate, there's still a link in every email, but we're really grateful and we really appreciate you. I just want you to all know that and hear that. In deference to Thanksgiving, there is no program next week. Of course, we wish you a really happy holiday. Our next program is on December 3rd. Veteran U.S. diplomat, peace negotiator, and senior fellow at the Carnegie Endowment for International Peace, Aaron David Miller, will be in conversation with Madeline Brand. It'll be an Israel update, Trump's plan, breakthrough or breakdown. Register for all of our December and some of our January programs in the email you'll get at the conclusion of tonight's program. Now, without further ado, please welcome tonight's outstanding moderator, Larry Mantle. He's a superstar broadcast journalist who has a very long-running talk show, probably the longest in all of radio, on public radio for 40 years. Larry has hosted Air Talk, a daily talk show. He's an extraordinary host, moderator, and journalist, and overall a great person. Most importantly, Larry is a vital member of our America at a Crossroads team. Before I hand over the show to Larry, I want to wish you all a very good Thanksgiving. We hope it is replete with family, friends, love, and gratitude. It'll be a time to focus on that which is right and good in our lives. Larry, now the show is yours.
Thank you, Janice, Zev, Mel. Thank you all so much. I'm very thankful to be a part of America at a Crossroads, and I hope I haven't worn out my welcome as this is my third consecutive week of moderating, which has just been an absolute pleasure. But you'll get someone fresh with Madeline coming up in a couple of weeks. You know, the range of guests that we've had over these past 3 weeks just reinforces the extraordinary job that Janice and Zev and Mel do in putting together the guest list for America at a Crossroads. And seemingly every week, the timing is impeccable. The guest perfectly relates to what's in the headlines. That's certainly true this week. This week, it's also particularly important that we get your questions because there are so many aspects of the law for us to go into with Mark. It's very important that we hear from you the issues that are of greatest importance to you. We're joined tonight for our conversation on the courts by Slate senior writer Mark Joseph Stern. In addition to analyzing the law, he provides commentary from a progressive perspective. He's Georgetown through and through with both undergrad and law degrees from the university, and he's been full-time at Slate for nearly a decade. And there's a good chance you've seen him on what used to be called MSNBC, now MS Now. Mark, so good to have you with us for America at a Crossroads.
Thank you so much for having me. It's really an honor to be here. And I have been looking forward to this conversation, even though some of what we discuss will be depressing. I promise not all of it will be.
Well, I can't imagine a better time to be someone whose beat is the law than right now, where every day there are things for you to report on and to analyze. So what is it like? You know, you've been doing this work for nearly a decade, and to now see this kind of flow of news to be reporting on. What's that like in your position?
So look, it's changed a lot. Like I said, unfortunately, a lot of what I'm writing about now is covering threats to the rule of law, covering the Supreme Court's ongoing shift to the right, the conservative supermajority's destruction of longstanding precedent and personal freedoms, and the the sort of magnification of lower courts through the influence of Donald Trump's many appointees. So it's very different from when I started, which was an era when Justice Anthony Kennedy sat at the center of the court. And even though Kennedy was conservative in most ways, he did have a kind of libertarian streak. And so he gave us decisions like Obergefell, which enshrined a right to same-sex marriage under the Constitution, and Whole Women's Health versus Hellerstedt, which continued protections for the right to choose. Those kind of rulings just don't come from the Supreme Court anymore. And furthermore, as we all know, like there has been a real push by the Trump administration to sort of bring the Supreme Court to heel and push the justices to rubber stamp every single thing that the government does. And for the most part, not always, but mostly, the court has complied. It has not stood up to Trump in the same way that, for instance, it frequently stood in the way of President Joe Biden and struck down many of his signature initiatives. So it's a much more conservative court. It's one that is very much in tune with the Republican Party's agenda. And the question is, you know, with the Republicans in control of the executive branch and a very pliant Congress, can the judiciary survive as an independent branch, or are we going to see it mostly fold into the executive branch and become sort of an outpost of Donald Trump's empire?
So you're saying that the Supreme Court is complying with Trump, but these are longstanding conservative justices who've had their own views about presidential authority. So why isn't this a case of justices who are in fact adhering to what they believe the law should be, not kowtowing to Trump?
So there are some cases where I think it's true that the Trump administration is simply aligned with longstanding conservative goals. One example is the unitary executive theory, which you may have heard of, this idea that the president has absolute control over the executive branch. He can fire pretty much anybody he wants. That is something that the justices on the right have long believed. And when they rule for Trump probably in June and allow him to fire members of federal agencies, they will just be vindicating an idea that's been sort of burbling up since at least the Reagan administration. But there are other areas where I really do think that the Republican appointed justices are shifting their views or reformulating their views to align with what Donald Trump wants. And there are some really clear examples involving the separation of powers, the idea that there needs to be independence between the legislative, executive, and judicial branch. I mean, a bedrock idea of the separation of powers in our nation is that Congress has control of the purse. You learn this in 8th grade civics. I'm sure it sounds familiar to everyone. The Constitution gives Congress power over appropriations. It does not give the president that power. In fact, it instructs the president to faithfully execute the appropriations that Congress passes. And that is because the framers were very afraid of a king. They did not want to replicate the monarchy that they had just, battled off. And a lot of the Republican appointed justices earlier in their careers wrote about the importance of the separation of powers and the importance of keeping the president away from appropriations and keeping the power of the purse vested in Congress. But this Supreme Court has entirely abandoned that principle time and time again. This Supreme Court has allowed Trump to refuse to spend money that Congress explicitly appropriated for certain purposes, to just pocket veto or pocket rescind billions and billions of dollars in cash that Congress said must be spent for X, Y, and Z reasons. And that is just impossible to square with what these justices have claimed to believe in the past. That feels to me like these justices saying, we kind of want to make Trump a king, and this is what he demands, control over the fisc, and so we're just going to give it to him.
So you're expecting that on the tariffs, that the Supreme Court is going to side with Trump on the tariffs if you hold this view?
So not on tariffs, because I think there is a difference between spending and taxes. And I think that the Republican appointed justices probably hate taxes more than they love Trump. The tariffs case is interesting because it is entirely separate from these big questions about appropriations and separation of powers that I was just talking about to some degree. I mean, there are some common threads, but it's really about the interpretation of this Emergency Powers Act that Congress passed in 1977 that gives the president control over certain trade functions, including giving him the ability to regulate importation into the country. So no previous president has ever interpreted this law to allow for the willy-nilly imposition of tariffs. No president has ever said, hey, I could just use this to slap tariffs on any country I want for however long I want, for any reason I want. But Trump has. And that presents a real problem for the Supreme Court. First of all, because we're now talking about taxes on the American people. The justices know Econ 101. They do understand that a tariff is ultimately going to be paid, at least in large part, by American citizens. And they are very hostile to taxes. There was a case last year in which the Supreme Court actually came one vote away from destabilizing our entire federal income tax scheme. So these are not justices who love taxes, but also they spent most of the Biden administration sort of formulating and articulating this principle that presidents can't seize on some agenda item and then scour the existing law books for some statute that they can kind of use to squeeze through their policy. So we saw this when the court struck down Biden's eviction moratorium, Biden's vaccine mandate, his student loan forgiveness program, some of his climate regulations. Over and over again, the Supreme Court said, look, these are major questions. And when a president is enacting a policy that involves major questions, we expect Congress to speak very clearly, and Congress didn't speak clearly in those cases. And this case, the tariffs case, is the textbook example of major questions in play. Because if Congress had wanted to give the president unlimited power over tariffs, you'd think that it would say that pretty clearly. I mean, the Constitution vests the power of taxes and tariffs in Congress alone, not the president. So you'd think if Congress were giving up that power wholesale, that it would say it pretty clearly, and it didn't. So I do think that there is a real chance these justices will strike down the tariffs, and they'll use that to say, look how independent we are from Trump. We aren't only doing his bidding.
But you'd said you thought their task was to try and make Trump a king. You would think if that's their goal, that then the tariffs would be a part of that. Or were you being hyperbolic with that?
No, what I would say is that the justices are smart enough to understand that striking down Trump's tariffs will only help him in the long run. I mean, these tariffs, I think the justices understand, are bad for the American economy. They're bad politics. They aren't polling well. They're making everything more expensive. I would say they're probably the single most unpopular item on his agenda. Every mainstream economist, many members of the business community, the corporate lobby, the Chamber of Commerce weighed in on this case against the Trump administration, even though they are usually allies of the Trump administration. And they said, look, Supreme Court, you need to draw the line here. And why is that? I mean, some of these parties just came out and said it. They were like, this is going to tank the economy. And I don't think that these justices want to see Trump and the Republican Party, by extension, flop so badly that Democrats, I don't know, win a Senate majority in the midterms. And then if Thomas or Alito want to step down, they can't because Democrats won't allow Trump to replace them. I think that the tariffs case is also best understood as an opportunity for the court, yes, to say we're being independent, to flaunt its putative integrity, but also to save Trump from his worst instincts in a way that will improve the political fortunes of this White House and the Republican Party.
Mark, in the past, haven't there been tariffs that have been enacted through presidential action? Now, is this only about trying to use the emergency provision as the vehicle for doing that, as opposed to a president having to keep total hands-off tariffs?
So great question. The answer is that there are, in fact, a number of statutes that allow the president to impose tariffs unilaterally, but they are narrower statutes than the emergency law that he has invoked here. They have a cap on how high the tariffs can be. They are limited in duration. They can't go on forever. They have to serve a particular purpose. Often the tariffs have to be preceded by a trade investigation. And so, like in his first term, Trump used those statutes to impose various tariffs on China and other countries. In his second term, he came in and said, this is too small scale for me. I don't want to be limited by these statutes. I want to be able to do whatever I want. And that is when his lawyers seized on the Emergency Powers Act and interpreted it for the first time to allow him to slap tariffs on any country for however long. And that played against him in court because, this idea of the major questions doctrine that I was talking about, one of the things that the justices look at is, are there other statutes that the president could invoke to do a more modest version of this policy? And indeed, there were in all of those other cases. There were statutes that Biden could have used for more modest climate regulations, for smaller scale student loan forgiveness. And the logic of the court was, look, he can use those, but he can't just take this kind of vaguely worded emergency statute and use it to do whatever he wants. And I think that's the same principle that's going to be at play in the tariffs case.
Let's move on and talk about yesterday's three-judge federal panel in El Paso that stayed the Republican legislative plan for gerrymandering Texas to provide up to 5 additional GOP House seats in the midterm election. Interestingly, it was a Trump nominee who wrote the opinion for the majority in that case. I know you were saying earlier that, these judges do Trump's bidding, but that has not been uniform. But certainly they've looked more kindly than have Democratic nominated judges. But what is the race-based argument that the plaintiffs made here? And do you think that this stay on the implementation of it is likely to hold?
So it's a really interesting decision, and it's a little complicated, but I'll break it down. What happened was Donald Trump wanted Texas to redraw its congressional districts to give, as you said, Republicans 5 more seats in the House of Representatives. The Texas legislature is controlled by Republicans, but they weren't super enthusiastic about this. They were like, it's going to be overtly partisan. It's going to stretch our margins kind of thin. It's not something that we really want to undertake. It'll look very bad. It could provoke backlash. And so the Trump administration then concocted a scheme to create a pretext for Texas to redraw these districts for reasons other than politics. And the pretext turned out to be race. And what happened was the Justice Department sent a letter to Texas claiming that its current map had too much race to pass constitutional muster. It took race too much into account. Specifically, the Justice Department said that it had too many districts that put together Hispanic and Black communities in one district and did so on purpose. And the claim was that's unconstitutional. You packed these Black and Hispanic communities together because of their race. You have to draw a new map to unpack those districts, or we may file a federal lawsuit against you. The United States of America will come thundering down with the federal suit. 2 days later, the governor sort of assented. He said, okay, the Justice Department says we have to redraw these maps, so we're going to redraw these maps. And the legislature proceeded to redraw the maps in a way that the court said, and I think it's pretty indisputable, was laser focused on race. The court took a bunch of Hispanic communities out of these earlier districts and redistributed them in a way that was designed to maximize Republican advantage. That was especially easy because there was a big swing toward Trump among Hispanic communities in 2024. So Republicans said, we're going to create some districts that have more Hispanics who are going to go for Trump. And then we're going to redistribute these Black voters throughout other districts that are deep red so that Black voters won't be able to elect Democrats even if they want to. And then they left the white districts alone. They were like, the white districts are fine. We're not going to touch them. We're just going to sort these Black and Hispanic voters as we see fit to create more districts for ourselves. That is sort of the one thing that the Supreme Court has said that state legislatures simply can't do. The Supreme Court has really gutted a lot of the Voting Rights Act. It's poised to dismantle what remains of it very soon. But the Supreme Court has been pretty consistent in saying that under the 14th and 15th Amendments, under the principle of equal protection, states cannot target voters on the basis of race and then discriminate against them because of their race in drawing electoral districts.
So what would the threshold, sorry to interrupt, Mark, but just what would the threshold be? You said, would it be, you have to show in whatever successive appeals there are that keeping the white voters intact was the evidence of this being race-based? Because Black and Latino voters are going to be dominantly Democratic, so that's a partisan gerrymandering. So is the evidence for what you're describing the fact that white voters were left alone in the districts?
So that was one piece of evidence. In cases like this, there's not usually like a single smoking gun. There's a series of facts that amount to the persuasive evidence. And so the court did cite the fact that these white districts were mostly left alone. But the court also sort of just pointed to the fact that the Justice Department told the Texas legislature to redraw these maps on the basis of race, which was not, in fact, legally required. I mean, the premise that you couldn't combine Black and Hispanic communities in the same district, it was totally made up. It was totally wrong. Like, even the Texas Attorney General's office recognized this. You know, the court said it was flat out wrong. I think as a matter of law, that's just correct. And so the sort of through line here is that the Justice Department told the legislature, redraw these in a way that redistributes the Black and Hispanic voters. So usually we are in a situation where it's the reverse, right? Where legislatures are secretly looking at race, but they claim that they're only looking at partisanship because the Supreme Court allows for partisan gerrymanders. Here we have the rare case of a legislature essentially admitting we were using race because that's what we thought we had to do, and that is unconstitutional.
So, Mark, if this stay holds through the appellate process and Texas's GOP favoring gerrymander doesn't happen, is California's Proposition 50 a totally separate issue? And could it withstand legal challenges at the same time that Texas's doesn't, and Democrats come up with a big net win?
So it's possible. The Justice Department has challenged the new Texas map as a racial gerrymander, but that's going to be a very steep uphill climb in court for a couple of reasons. One is that this was a map that was not just passed by the legislature, but then supported by a supermajority of California voters. And
let me just say, you said, I think, Texas accidentally, but you meant California. Just wanted to clarify.
California's map has been challenged by the Justice Department as a racial gerrymander. And that's going to be an uphill climb because, again, Proposition 50, the enactment of this map, was approved by California voters. And the courts are very, very hesitant to impute racist motives to an entire state's electorate that passes a law through a proposition. It's very different when, you know, a bunch of legislators in a back room just ram through a racist map, as opposed to legislatures proposing a map and then allowing the people to vote on them. And so I think it's pretty unlikely that a court's going to say that California's map is a racial gerrymander and that every person who voted to approve it harbored racism deep in their hearts and that it therefore has to be struck down. So I think that California's map is very likely to survive. But, you know, the reality is I think it's pretty unlikely that the Supreme Court upholds this judgment against the Texas map. Part of that is that the Supreme Court is just super hostile to voting rights. The Supreme Court, as I just said, has done a lot to dismantle, you know, protections for democracy and access to the ballot already. The Supreme Court has repeatedly blocked decisions that attempt to make it easier to vote before an election or create fairer districts and better representation. And just today, the dissenting judge from that decision that I was talking about, Jerry Smith, issued a truly wild 100+ page decision in which he accused the majority of essentially being in the pocket of George and Alex Soros. He mentioned George Soros 17 times. This is a sitting federal judge appointed by Ronald Reagan. He accused the majority of lying and of doing the bidding of the Democrat Party. He just had a broadside against the majority's decision that seems aimed at the Supreme Court's conservative justices to tell them that he thinks this ruling is illegitimate and they should block it before the 2026 election. And I think that gambit is more likely than not to work.
So I wonder, you know, you have states like California that have done just about everything they could to accommodate voting. Votes are counted even if they're received after the polls close on election day, as long as they're postmarked before the polls close on election day.
Which there will be a
Everybody
Supreme
gets.
Court case about this
Well, I
term,
was
by the
going
way.
to, I was going to get to that. So, and everybody gets a vote by mail ballot in California. That's the default is opt-in. So, or opt-in. I always get those back. Everybody gets one. So
Everybody,
my
yep, same in
question,
DC.
yeah. So my question is, if the justices tend to be favorable towards states kind of, setting their policies, and if they want more restrictive ones, we let them do it. Does that mean that California, even if Trump tries to say, no, you can't accept ballots after the polls close, you can't do universal vote by mail, whatever it is the high court likely to say, hey, states run the elections?
It would be nice if the court showed consistency in this area. I would say it has a kind of a checkered history on this subject matter. I agree that if the court is going to generally uphold restrictive voting laws and unfair maps, then it needs to at least defer to other states that are trying to do right by their voters and running elections fairly with integrity. But the court came one vote away from abolishing independent and bipartisan redistricting commissions about 10 years ago. The court came very, very close to throwing out thousands of mail ballots that arrived shortly after the election in Pennsylvania in the 2020 race. The court has not always deferred, and the Republican appointed justices have not always deferred to states that want to make it easier to vote and easier for ballots to be counted. So I am somewhat worried about this case that you teed up that I mentioned, where the Supreme Court will decide whether states are allowed to count these ballots that are postmarked and mailed before or by election day, but that arrive shortly thereafter. To be clear, it's not just California and it's not just DC. More than half the states count late arriving ballots, including Texas and Mississippi. So it's not even just a red-blue thing, although they are more common in blue states. But the lower court here ruled that states are not allowed to count late arriving ballots. Its decision was really incoherent. There is no federal law that says states can't count these late arriving ballots. The way that the Constitution describes these sort of procedures is that states get the first say and Congress can come in and change the rules if it wants. Well, a bunch of states have said that they want to count late arriving ballots, and Congress hasn't said that they can't. So the presumption should be that the states get to do what they want. But again, the Supreme Court has not always deferred to the states when they want to expand access to voting. So it's one that I would advise cautious vigilance on.
And since we're talking voting, I did want to talk about the Supreme Court case you alluded to earlier in passing. That's the Louisiana case involving Section 2 of the Voting Rights Act. And so the question is, when is that decision going to come in? Because it could have an effect, of course, on this whole redistricting process. And you've got the deadline for candidates to file to run that, you can't redistrict after you've reached that deadline. So, and these are coming up in some states pretty early in 2026. So what do you see as the likely timeline for this?
So, I do think that the Supreme Court will likely weaken what remains of the Voting Rights Act and make it easier for states to gerrymander Black and Brown communities into electoral oblivion. The best estimates show that an aggressive response in the South to such a decision could eliminate 15 to 19 Democratic seats. It would allow states like Mississippi and Louisiana to have all Republican delegations. It would allow states like Florida and Georgia to eliminate what Democratic districts remain, create an even more skewed map. I think all of that is quite possible, given the tenor of oral arguments. The Republican appointed justices are very hostile toward the Voting Rights Act. They don't think that states should be restrained from sort of carving up districts in the way that they see fit, as long as they pretend that they aren't focusing on race. As I mentioned in our earlier conversation, states have to at least pretend like they aren't being racist, which is what the Texas legislature failed to do. But I don't think we're likely to get a decision until, I would say, April, May, or June. And I think that will be too early for the states to implement that decision by redrawing new districts.
You mean too late? The decision will come in too late for them.
Yeah. Sorry. The decision will be too late. And so states will not have time to redraw their districts at that point. The liberal justices have a real role to play here if they want to. There is a sort of protocol, a tradition on the court that they don't release opinions until the dissents are ready, even if that runs out the clock, so to speak. The liberal justices could spend a few extra months working on their dissents to make sure that this decision comes down in June instead of December. And that would mean that the impact of that decision wouldn't be felt until 2028 rather than 2026.
Mark, let's talk about leaving election law aside for just a moment. President Trump has attempted to deploy the National Guard to a number of cities, including Memphis. We had a Tennessee judge who stopped that from occurring. We've had legal action in Portland, Chicago as well. So, where do we stand on the president's ability to do this? I know DC, where you are, because of course it's a federal jurisdiction, the president's been able to do this, but elsewhere, what do you see happening?
So we're waiting on the Supreme Court. At any moment, I could get a call from the Supreme Court and they could tell me, hey, we just released a decision on the National Guard. And we could learn whether or not the Supreme Court will allow these deployments of the National Guard in Portland and Chicago and, the other places that Trump wants to send them. The legal question in this case is very interesting. I think probably most people are aware that like JFK and Eisenhower sent in the National Guard when southern states refused to desegregate their schools and comply with integration orders. But that was under a different law. That was under the Insurrection Act, which is only really invoked when there is this kind of disobedience to federal court orders or federal laws. Trump is trying to use a different statute to send in the National Guard, and it's a very narrow statute. And as relevant here, it only allows the president to federalize and deploy a state's National Guard, because the National Guard is usually in control of a state and its governor. The president under the statute can only take it over when he is unable to execute the laws of the United States with regular forces. So there are two questions there. The first is kind of a factual question. Can the president still execute the laws in Portland and Chicago without the National Guard? And the other is really a legal question. What does regular forces mean? What does it mean for the president to be unable to execute the law with his regular forces? So the Supreme Court is going to have to answer both those questions. On the factual question, look, I think that it's very clear that the president does not have the authority to send in the Guard, because the situation on the ground in both Portland and Chicago is entirely under control. There was a federal judge in Portland who just issued a 106-page decision running through the facts of the last few months in Portland and explaining that there is no chaos on the ground, that there is no threat of obstructing federal law enforcement, that the ICE facility there, ICE agents are all being now peaceable and are not threatening the federal government. So, go ahead.
No, I'm sorry. I was just going to say, but in Tennessee, I don't understand, because there, the governor welcomed Trump sending in the National Guard to Memphis, and yet the judge in Tennessee said, no, this is the president doesn't have this authority. So what happened there that even when the governor said it was okay, that the judge said no?
So in Tennessee, it was a state judge, not a federal judge. And that judge held that the governor does not have unilateral authority to send in the Guard for this kind of purpose, that the legislature needs to play a role here, and that the legislature has to approve the action as well. So that was I was surprised by the decision. I read the laws. It made sense to me. I'm not an expert on Tennessee statutes, but that was a sort of like separation of powers within the Tennessee government, that the governor can't just wing this on his own, that the legislature needs to step in
Because
as
in
well.
California, I think Governor Newsom can call in the National Guard. He doesn't have to consult with the legislature
That's
in
right.
California to do that.
That's right. And the governor is typically the commander in chief of his state's National Guard until the president chooses to come in and override him. So yeah, we'll see if that decision holds up at the Tennessee Supreme Court. I'm kind of skeptical. But you're right that the usual rule is that the governor is in control. But yeah, so we're waiting to see what the Supreme Court says. And so the Supreme Court has to decide, is it really chaos in Portland and Chicago? And then the Supreme Court also has to decide, what does it mean for the president not to be able to enforce the law with regular forces? Does that mean that he tried to use federal agents like ICE and CBP and federal marshals? Does it mean that he tried to send in the military? That's an argument that the Supreme Court actually expressed a lot of interest in, that he has to send in the regular army before he can send in the National Guard. It's all really kind of untested terrain, untested territory, but we're due for a decision very soon, probably before Thanksgiving.
So let's move on to the case of former FBI Director James Comey and his prosecution and the absolutely blistering things we've heard now from two straight judges.
Yes.
That the grand jury didn't review the indictment. You've got issues, of course, on the statute of limitations, selective prosecution argument that Comey's attorneys are making. I mean, so there's a lot going on. Just, briefly kind of unpack this. And this seems like a very, very uphill battle for the prosecution here.
So the fundamental problem that the prosecution has faced over the last few days is that it's not at all clear whether the acting U.S. attorney for the Eastern District of Virginia was lawfully appointed. And even if she was, it is not clear that she followed the necessary protocols to secure a legitimate indictment against Comey. So this individual is Lindsay Halligan. She was an insurance lawyer in Florida before she joined President Trump's legal defense team earlier this decade. And when the previous career prosecutor in that office refused to indict Comey because he felt it was a sham, he was pushed out and Trump installed Lindsay Halligan instead. In between, for one day, there was a woman who served as acting U.S. attorney who I actually went to college with, who also refused to bring this indictment and was then pushed out. So, credit to Maggie Cleary for her one-day tenure in this office. But after she was pushed out, Lindsay Halligan was installed. And she had never presented a case to a grand jury before. She didn't know what she was doing. She didn't really understand criminal procedure. And so it looks like she failed to present the final version of the indictment to the grand jury for its approval. And there's not a lot of ways that you can screw up with a grand jury. Like, grand juries famously will indict most people. It does appear that a majority of the grand jury voted to indict Comey on these charges, which I think are very weak, but that's another topic. But she never got the full grand jury, or at least the majority that voted to indict, to actually look at the indictment and ensure that it reflected their charges. That is a defect in the indictment. It means the indictment can't stand. I think that indictment is very likely to be thrown out. You have to get the grand jury's approval on the exact indictment that you end up submitting in court. So, the statute of limitations will be something of an issue here, because Comey was indicted like a day before the statute of limitations was set to run out on his alleged crime, which I still really don't think was a crime. But there is a federal statute that extends the statute of limitations by 6 months when there is a defect in an indictment. And so I think that won't be an insurmountable issue. I think the bigger problem will be getting a conviction at trial, because the accusations against Comey just don't make a lot of logical sense.
So I was going to ask you, what you thought this might say about further Trump-directed prosecutions, but it sounds like this is pretty much in and of itself. But overall, when you have defense attorneys who are going to go and say, this is clearly a politically motivated prosecution, look at what the president said, look at, are any of these going to be able to stand up to that sort of scrutiny regarding partisan targeted charges?
So I think if any of them will, it'll be John Bolton's. Unfortunately, the facts in the Bolton case seem pretty clear that he did violate some statutes. Now, it's probably statutes that other people have violated who have written books about their time in government, right? He revealed secret information. He may have maintained and shared files that he wasn't supposed to maintain and share. But if he did indeed break the law, I think there's a real chance that a jury will indict him. All these other cases, the Comey case, the Tish James case, right? She's the Attorney General of New York. I think that those don't stand a chance. And I don't know if a judge throws them out immediately because they have these defects, they're too weak, there's a selective prosecution claim, or because they go to a jury and the jury just won't convict because they call BS. But I find it very unlikely that these will end up in a conviction. And, for evidence of that, just look at what's happening in DC court now pretty much every week, right? We've seen grand juries refuse to indict. We've seen trial juries refuse to convict. They refuse to convict the sandwich guy. They've refused to indict people who have allegedly threatened or interfered with ICE officers. Like, people are pretty smart when they're put on grand juries and juries. They try to do their duties diligently, and they can see, with the help of a decent defense attorney, that what the prosecution is doing here is under the direction of Trump and not really in the interest of justice.
Just one more question before we have some great viewer questions, but I know you write about a lot about LGBT plus legal issues. So I wanted your take on the non-binary designation on passports going into effect, because I wasn't sure what the history, who put the non-binary on passports, how did that get established, and then how has it happened that it's removed because the president says it shouldn't be there?
So there is no federal statute that explicitly says that your passport has to have a gender marker that aligns with your biological sex or your gender identity. That has been at the discretion of the executive branch for decades. For 33 years, until 2 weeks ago, the government has allowed transgender people to change the gender marker on their passport. So this was under George W. Bush's 8 years. Donald Trump's first 4 years, transgender people were allowed to change the gender marker on their passport. Under President Joe Biden, there was another change that individuals could have an X marker if they are non-binary or intersex. That was actually the result of a court settlement because a district court found that it was discriminatory to deny intersex people a different marker than male or female. And now Trump has revoked all of that, both the non-binary marker and the ability of trans people to change their gender marker. And the Supreme Court affirmed that by a 6-3 vote. There's a lot to say about that decision. But I guess I just want to focus on the fact that, it was really disruptive to many, many people who have assumed that for years they would be able to get a gender marker that reflects their lived identity. The reason why previous Republican presidents allowed for that is because you don't want the guy at the border to look at your gender marker and say, wait, you don't look like a man. Why does this say you're a man when you're presenting as a woman? The whole point of these vital documents is to help others identify you correctly. And so having a gender marker that doesn't align with what you look like is really irrational. And I think maybe the most upsetting thing is the Supreme Court did this over the shadow docket. This is, the way that the Supreme Court does these decisions without oral arguments, without full briefing, without full discussion at conference, without all of the deliberations that sort of legitimate the court's work product. They just issue these unsigned decisions saying Trump can do this, Trump can do that. And this was one of those unsigned decisions saying Trump can take away these gender markers. And the court was able to, because it just issued this over the shadow docket, ignore immense evidence on the record that trans people suffer under this policy, that they're subject to invasive searches, including strip searches, that it doesn't further any government interest, and that it was rooted in unconstitutional hatred towards trans people. The Supreme Court just ignored all of that. The conservative majority did. And I think that is a good example of a deeper pathology that we're seeing in a lot of these shadow docket decisions, where the majority just closes its eyes to all of the bad motives and consequences of what Trump is doing, just puts them out of the frame and greenlights whatever Trump says he wants to do.
Let's get to viewer questions here. Diane asks, is there a way to intervene with litigation on the president's use of his office to promote his family's cryptocurrency business and other profit-making ventures?
Unfortunately, the answer is likely no. If there were a Democratic controlled chamber of Congress, then maybe. So if Democrats, say, won the House of Representatives in 2026, which Texas and other red states are trying very hard to prevent, then Democrats could have committees look into this. Those committees could issue subpoenas. They could order people to testify. They could gather evidence. They could, at a bare minimum, reveal to the public the full scope of Trump's self-dealings. But with this completely pliant Congress, there is no hope of that happening. And then the other part of the problem is that because a part of Supreme Court precedent, the people who enforce the laws are the people in the executive branch. And Trump doesn't allow anyone to stay in the executive branch if they investigate him or they go against him. I mean, this is why one of Trump's very first moves when he came into office the second time was to fire nearly 20 inspectors general, right? Congress wanted the inspector general's offices to be independent, to look into the president and his misconduct. Trump said, I'm going to fire you unless you're loyal to me. And the Supreme Court just allows that kind of thing to happen now. So I think until Democrats gain real control in DC, it is unlikely that we see movement on the issue of his corruption and self-dealing with crypto.
We've had a number of viewers, including Susan, want a little more explanation on the shadow docket. We were just talking about it. And they're wondering, well, why is it being used more frequently in the past? And does it still set precedent?
So it's just to be clear, it is being used now exponentially more often than it ever was in the past. This is a novel development. My friend Steve Vladeck, who is a Georgetown law professor, wrote a terrific book called The Shadow Docket that I encourage you to buy. I know a lot of people...
He coined the term, didn't he?
Yeah, he didn't coin it. He popularized the term.
Okay.
He did, I think, inspire many people to dress up as the Shadow Docket for Halloween, which I really appreciated, spreading awareness. But, you know, I would say that what really changed was that the Supreme Court, for the first time in a long time, gained a very, very conservative supermajority that was eager to affirm much of Trump's agenda as quickly as possible. And in the previous 4 years, to block much of Biden's agenda. Before that point, for many years, Anthony Kennedy was the swing vote. There were 4 liberals and 4 conservatives in Kennedy. And then before that, there were Kennedy and Sandra Day O'Connor, who was more of a moderate. And so you didn't have 5, let alone 6 justices who shared like almost all the same views, especially about presidential power and major public policy, who were willing to just kind of ram those views through using brute force. And that changed with the appointment of Brett Kavanaugh and then the appointment of Amy Coney Barrett. And that is when the use of the shadow docket really skyrocketed. So, you know, these justices in the majority, they don't want Trump to have to wait a year to implement his anti-trans passport policy, right? They don't want him to have to wait through a trial in the district court and an appeal to the circuit court and then, oral arguments at the Supreme Court and a decision in June. They want to let him do it now because they think he's entitled to, and they have the votes to make that happen. And that is what has changed since the first term.
So if, let's say that the court was silent on the ability of people to designate gender or put the X for non-binary or intersex, would you just have that then going back and forth between the courts? Here's a court that says, yes, he can do it. Here's a court, no. In the meantime, passport rules just would go back and forth until it reaches the high court?
No, because what happened here is that a district court issued a decision that bound the federal government with regard to all transgender, non-binary, and intersex people. The district court issued a ruling that vacated, in the terms of the law, or essentially repealed the Trump policy and said you can't enforce this policy against anyone. So if the Supreme Court had not intervened, then that would have stayed in force until a higher court did reverse it, if it ever did. And it wouldn't matter if the government, tried to litigate this in a different court, that injunction or vacator would remain in force. So it wouldn't create the kind of inconsistency or ping-ponging that I think a lot of defenders of this court claim, there would still be one decision that laid down what the law was until the Supreme Court intervenes.
And haven't there been cases where the district court has ruled against the president and that has been allowed to stand, even if, that it could have been determined on the shadow docket that he had the latitude?
Yeah, so the Trump administration is very savvy about what cases it brings on the shadow docket. So it doesn't appeal every single loss in the lower courts over the shadow docket. It tries to find the ones where it thinks it's most likely to prevail. And so, to give one example, Trump's executive orders punishing law firms that represent and work with Democrats or have DEI policies or hire people he doesn't like, those lost in the district court. They lost very badly. There was not a lot of love for those executive orders. And the Trump administration could have shot that straight up to the Supreme Court and said, please allow us to implement these orders against the law firms, but they didn't, because they knew they would likely lose, because this is not an area where the Supreme Court is clearly aligned with the Trump administration. So one of the reasons why Trump keeps winning in these shadow docket cases, and there have been more than 25 at this point, I think, is because it's 25 out of more than 100. And the government is very careful about which ones it brings over the shadow docket and which ones it says, okay, we'll do this the slow way.
Victor asks, has Trump broken with the Federalist Society, and what is the relationship between Federalist and the Heritage Foundation, and how does his break with the Federalist Society impact potential future judicial appointees?
So I don't really believe that he's broken with the Federalist Society, but I do think that he is unhappy with a number of judges who were recommended to him by the Federalist Society. That includes Judge Brown, who wrote the decision striking down the Texas gerrymander. Judge Brown is a conservative Republican. He was a Federalist Society stalwart for many years, but he also, as we see, has some integrity and independence. And Trump doesn't want that in his second term appointees. And so he's, I think, exercising even more scrutiny over the names that the Federalist Society is producing for him to make sure that they will be absolute loyalists. So, for instance, there was a guy at the Justice Department named Emile Beauvais, who was, I think, acting deputy attorney general in the early months of Trump's second term. He's the one who struck the corrupt bargain with Eric Adams to drop the ethics prosecution if he would enforce ICE laws in New York City. He's the one who allegedly told federal lawyers and officers to ignore court orders and to illegally deport Venezuelan migrants to a terrorist prison in El Salvador. He allegedly told his deputies to F the courts and just, deport these people illegally. He's now a judge on the Third U.S. Circuit Court of Appeals and serves a lifetime tenure. That is the kind of guy that Trump wants on the bench now. Not somebody like Judge Brown, who has some integrity, but someone like Emile Beauvais, who is nothing more than a hatchet man for this president. And so, I think that he's still going to consider who the Federalist Society recommends. Heritage Foundation has some say here too. I do think that he's even more closely aligned with Heritage this term than he was last term, but he is going to try to make sure, especially for those appeals court seats, that these people are loyal to him first and foremost, and that they aren't just conservative, they are MAGA through and through. And that is a difference from the first term.
I've just gotten an update from Janice that President Trump signed the House bill on the Epstein files being released. So
we'll see what happens.
We'll see what actually comes out. Let's see. We have a number of viewers who have asked about the latitude of the Supreme Court over state running of elections. We know the High Court, for example, the Voting Rights Act has been able to provide its interpretation, its decisions about the constitutionality of different provisions. So Ruth and a number of others asked, well, how is it that the Supreme Court has any sort of say over how states, the constitutionality of how they conduct elections?
So first of all, the Supreme Court can always enforce federal guarantees like equal protection with regard to how states are running their elections. So in the Voting Rights Act case, it's called Calais versus Louisiana, the Supreme Court may say that states cannot consider race in trying to protect the political power of racial minorities, which sounds very backward, but I think it's where the court is going, because for many years, the court has said the opposite, that states actually do need to consider race so that Black and brown communities have real political power. The court's likely to sort of reverse that holding, and it'll do so under the Equal Protection Clause. It can say it violates equal protection for states to consider the race of voters when drawing district lines, even if they're trying to protect those voters and enshrine their political power into law. There's also an issue that federal law on elections, on federal elections, supersedes state law. So like I was saying before, the rule is states get first pass, but Congress can come in and change the rules. And
so just an example, could Congress say you can't accept any ballots after they haven't done that, but they could do that? And then the Supreme Court, if someone challenged it, could review that?
That is exactly right. So then the Supreme Court could come in and say, oh, well, the federal law says that you can't count mail ballots after an election, so states can't do it for federal elections, even if they want to. So that is another way that this happens. And that is what that case is about. And there are a lot of cases like this, and they go both ways. There are some states that are trying to demand proof of citizenship in order to vote. There are some states that are trying to let non-citizens vote. And in a lot of those cases, the question is, well, what does federal law have to say about this? And if Congress has said nothing, does the Constitution tell us anything? There are very, very messy cases.
Diana asks, can President Trump be investigated and potentially charged after serving as president based on ways that he monetized his businesses during the presidency? So her argument, let me just say, her argument is, well, if he enriched himself not in the course of formal presidential duties, is that chargeable?
So in theory, yes. The problem is that the Supreme Court's presidential immunity decision interpreted official acts very, very broadly. So last year, the Supreme Court ruled that the president cannot be criminally prosecuted for official acts that are core to his constitutional powers, and then presumptively, like as a rule, can't even be prosecuted for official acts that are on the outer perimeter of his constitutional power. And the way that the court described that outer perimeter encompasses almost everything. I mean, there's a question now of whether Trump writing hush money payments to Stormy Daniels in his first term was an official act, basically because he did it from the White House. That is how broadly the Supreme Court has defined these official acts. So, in theory, a future prosecutor could say, oh, well, he did this on his private time. He had these dealings with crypto kings and made these bargains on his private time. So it's not an official act. So we can still charge him. But he would come back and say, oh, but this was part of my broader effort to engage in international diplomacy with the Saudis. That to get this agreement with the Saudis, I needed to work with this stablecoin financier who said that he might be willing to extend a line of crypto credit into the Saudi kingdom if we make this deal. Whatever. I'm making that up, but that's the kind of thing that he will say. And as soon as he says that, courts have to stop. They can't interrogate it. They can't introduce it into evidence. They can't do anything.
He just declares that, and then that has to be respected by prosecutors in the courts.
There is an extremely heavy presumption that once he declares it, that is the end of it and that is the truth. And it is extraordinarily difficult for prosecutors to surmount that, because in part they can't question his motives. They're not allowed to ask whether he was genuinely doing this out of a political or constitutional reason, or if it was for self-gain. The decision says that they can't look into motives, and that makes it very difficult to prove corrupt intent.
Final question for you from our viewers. There's so many great questions we didn't have time for, but question is about whether you think it would be wise to expand the size of the Supreme Court, and what you think of the likelihood of that happening in the foreseeable future.
So, I guess what I would say is the Republican Party already changed the size of the Supreme Court once in recent memory, and now we're just haggling over the number. When Justice Antonin Scalia died, Republicans blockaded any replacement and kept the Supreme Court at 8 justices for well over a year. So the idea that 9 justices is sacrosanct has really been shattered. It also isn't in the Constitution. It was not the number in early American history up until the 1860s. It was in flux. I think that if Democrats really want to play hardball with the courts, they are going to have to consider expanding the number of justices. Previous presidents did it. Lincoln did it. I do think that it needs to be on the table if Democrats want to play hardball. It's dangerous because it can delegitimize the entire judiciary. It's playing with fire.
Finally, a chance for you to just close us out with your thoughts about the importance of decisions we're going to be seeing over the next year, because a lot are coming down.
Yeah, I guess I just want to pivot a little bit away from the Supreme Court. Obviously, those decisions are going to be incredibly important. The expansion of executive power is going to be something to keep a very close eye on. I will be very worried about new powers given to the president. I think this is a very bad time for the Supreme Court to be transferring even more power away from Congress to the executive branch. But keep an eye on the district courts and the appeals courts, because we have seen a lot of really courageous men and women in the lower courts stand up to Trump. And like I said earlier, a lot of those decisions have stood. They have not been overturned. We are seeing judges in the face of death threats and constant political harassment stand up for the rule of law and say no to the Trump administration and draw a line in the sand. And that is what we have to support and what we have to look to if we ever want to find our way out of this mess. I do not want anyone to think all hope is lost. It is not. We are still seeing much of the judiciary function as it should. We are not past the point of no return. The rule of law is still alive and well in many courtrooms across the country. And I think it is our duty to support the judges who are doing this right and to loudly criticize and condemn judges and justices who are sort of, surrendering their independence to this president, because that is not the job. That is not what the Constitution envisions. And we as a citizenry just should not tolerate it.
Mark, thank you so much for being with us this evening. We really appreciate you spending the hour with us tonight.
Thank you so much. And those were really great questions. Thank you to the listeners for tuning in and asking them. I really appreciate it.
Our viewers are so good. And I always feel badly because there's so many more great questions we have time for. But thank you so much, Mark. And I'd ask you to please, as a viewer, to contribute to support this nonprofit, Jews United for Democracy and Justice, which puts on these great programs each and every week. You can make your tax-deductible contribution, which I know many of us around the end of the year are looking to do, by going to the website jewsunitedfordemocracy.org. jewsunitedfordemocracy.org. You can see right there where to make your contribution to support these programs, and we appreciate it very much. Now, next week, we are off. There is no America to Crossroads program in observance of Thanksgiving. 2 weeks from now, veteran diplomat and peace negotiator Aaron David Miller is with Madeline Brand for an update on Israel and President Trump's plan for the Middle East. All of us at America at a Crossroads wish you a very good Thanksgiving. We hope you enjoy your week off. Maybe you can go to the YouTube site for America to Crossroads and see one of the programs that you might have missed next week as you catch up on some of those. Again, thank you so much. Have a wonderful Thanksgiving week.